relevance of limitations in the criminal justice system is always a subject which has fascinated not only the lawyers, students, but as well as judges. Because a lot of us keep on discussing and reading the Limitation Act as to whether the Limitation Act is applying only simpliciter to the civil proceedings or as well as criminal proceedings, or there are special provisions under the criminal justice system. These all aspects to us will be shared through PPT and otherwise by Mr. M. Karunanithi, Advocate, Member, Law Commission of India, who is also a special prosecutor for CBI cases in High Court panel, as well as for Union of India. The previous session done by him is already doing so well on the YouTube, and you can all check it out regarding the relevance of pleadings in the criminal jurisprudence. Like on the previous session, we had apprised that Mr. Karunanithi has created his niche in the criminal area. Therefore, he has been made a part of the Law Commission to look into the aspects which can further help us in the betterment and development of the criminal system as well as other marches of law as well as aspects of law. I'll request Mr. Karunanithi to take over. Thank you for sharing your knowledge to us.
Good evening, learned brothers and sisters who are all connected here. I am starting this session with a great respect and thanks to the Beyond Law series learned friend Mr. Vikas and his team for having given me this nice opportunity to meet the lawyers across the country. No doubt, pleadings in criminal prosecutions, as I already taken a lecture on the subject, pleadings is very much known to everyone in a civil law, but it is not available in criminal law, though not directly. But pleadings in criminal case is very much necessary. Like the same, the Limitation Act 1963, there is a law specially codified in the name of the Limitation Act 1963, but there is no special provisions, specific law, special enactment governing the limitation in the criminal prosecution. But anyhow, but there is a provision in chapter 36 of Code of Criminal Procedure, sections 467 to 473 of Code of Criminal Procedure 1973. My contention is the word limitation is coined in section 467 to 473 in chapter 36 of CRPC. My learned brothers and sisters are well known about the chapter 36. The way I have taken this topic, or why the learned friend has given me this topic, is whether section 467 to 473 alone prescribes limitation, or is there any other provisions in Code of Criminal Procedure speaking literally limitation in any way. On that search and research, I find out there are many provisions speaking limitations, though not directly. Let me take from first information to the final report, even after the conviction or acquittal rendered by the trial court. It is not in dispute. It is not in dispute. The investigation commences as soon as first information report has been registered. As per section 2H of CRPC, investigation means collection of all evidence. The collection of evidence will come into play only after the registration of FIR. No doubt, anyone can set the criminal law in motion. There can be no dispute over that. There cannot be any second opinion over. But whether this is a absolute rule or is there any limitation or restriction for the general term. Anyone can set the criminal law in motion. The very registration of FIR, there is a restriction. The investigation, there is a restriction. Taking an accused into custody, there is a restriction. And the grant of bail, there is a restriction. In the trial, there is a restriction. After conviction, suspension of sentence, there is a restriction. In order to have a better appreciation, better understanding, I want to compare the Limitation Act 1963 with the criminal law. The Limitation Act 1963 has been repealed and re-enacted as per the third report of the Law Commission of India. The Limitation Act, the Indian Limitation Act 1908 was modified and re-enacted as the Limitation Act 1963. What the civil law, what the Limitation Act 1963 says, it bars the original jurisdiction. Suppose we take it granted, case of money suit on promissory note, whatever may be the amount covered under a promissory note, within the time prescribed under law, that is within 3 years, the suit necessarily has to be filed. So the cognizance has to be taken within 3 years. So even 1 day delay cannot be condoned. So as per section 3 of the Limitation Act 1963, let me read section 3 of Limitation Act 1963. Subject to the provisions contained in sections 4 to 24, every suit instituted, please underline, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. So the original jurisdiction, the extension of time, section 5 of Limitation Act will not come into play. Section 5 of Limitation Act will come into play. Let us compare original jurisdiction, appellate jurisdiction, and revisional jurisdiction are there. Whether in the criminal prosecutions, in the criminal justice delivery system, whether the original jurisdiction is there any limitation, or if we say yes, there are limitations, whether as per section 3 of Limitation Act, whether criminal prosecutions are absolutely barred, or is there any provision like section 5 of Limitation Act. Let me take section 467 of the Code of Criminal Procedure 1973. The limitation, as per the constitutional bench of the Honorable Supreme Court of India, we have to read the provisions with the heading. It must be conjointly read. A limitation for taking cognizance of certain offences. So chapter 36 heading very clearly convey a meaning, limitation for taking cognizance. So no doubt there is a limitation for what? Limitation for taking cognizance of what? Of certain offences. So in criminal prosecution, in criminal justice delivery system, taking cognizance has been limited by section 467 and 468 of Code of Criminal Procedure 1973. My doubt is whether section 467 and 468 of CRPC is applicable to all the offences. No, there are categories under section 468 CRPC. The period of limitation shall be 6 months. The period of limitation shall be 6 months if the offences is punishable with fine only. 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. 3 years if the offences is punishable with imprisonment for a term 1 year but not exceeding 3 years. So if the offences are punishable more than 3 years, if an offence is punishable more than 3 years, then section 468 of CRPC will come into play. The next question my learner brother may post, whether section 468 CRPC is absolute, or if there are any provisions to extend the limitations contained in 468 CRPC. Before that, I want to say one more thing. Section 467 and 468 speaks about taking cognizance. What has been limited is the taking cognizance of offences. No doubt, learned judicial magistrate and learned judge has taken cognizance not against the offender, but cognizance has been taken of offences. But what action of the learned magistrate would amount to taking cognizance has not been defined in the Code of Criminal Procedure. Section 190, Section 190 of CRPC speaks about modes of taking cognizance of offences. But what action of the learned magistrate or what action of the learned judge would amount to taking cognizance has not been defined. At this juncture, I want to explain. I want to speak one more thing. When an accused is produced before the learned magistrate, when an accused is produced after arrest before the learned judicial magistrate with a request to take him into custody, no doubt the learned judge, learned judicial magistrate can take the accused into judicial custody on application of judicial mind. Suppose an FIR has been drafted under section 153 and 295A of Indian Penal Code. Now the accused has been produced before the learned magistrate. As I stated earlier, as soon as the learned judge is applying his judicial mind into the facts of the case, the learned judge is deemed to have taken cognizance. Now the judge remanded the accused into custody. That is, he has authorized the detention of the accused into judicial custody. In order to take cognizance for an offence under section 295A or under section 153A of Indian Penal Code, the cognizance can be taken only on a sanction to prosecute. No court shall take cognizance except on a sanction. Now, my question is whether the cognizance taken, that is the taking of accused into judicial custody, remanding the accused into custody, is legally valid or not, because at the time of remand, request for remand, except the first information report and the statement of accused, no more documents are available in clear. The sanction is not placed before the court. On the date of occurrence, accused was secured, produced before the learned magistrate for the purpose of taking him into judicial custody. Whether the action of the learned magistrate taking him into a judicial custody is legally valid or not. This question has been answered by the Honorable Supreme Court of India. No doubt taking an accused into custody amounts to taking cognizance, but for the very limited purpose. What has been barred by law is under section 195 of CRPC is the bar is to take cognizance for the purpose of trial. So the case from High Court of Karnataka was set aside by the Honorable Supreme Court. At the fake end of my lecture, I will give all the decisions. So no doubt. But what has been barred under section 468 CRPC is taking cognizance of offences. The taking cognizance of offences, there is a provision, namely section 473, extension of period of limitation in certain cases. I want to compare section 473 of CRPC with section 5 of the Limitation Act 1963. Let me read section 5. Extension of prescribed period in certain cases. Any appeal, underline the word, any appeal or any application other than an application under any of the provisions of Order 21 of the CPC may be admitted after the prescribed period. So as per Section 5 of the Limitation Act, the original suit, we cannot apply Section 5 to the original suit, that is only in appeal or any application other than Section 20, Order 21 of the CPC, Section 5 is applicable. Exact judgment on the point is AR 2000 Delhi 336 Division Bench, Ashok K. Kurana versus Steel Manufacture, AR 2000 Delhi, page number 336, Ashok Kurana versus Steelman Industries. So now let us compare this Section 5 with Section 473 of CRPs. Let me read Section 473. Learned brothers and sisters, please kindly pardon me. I am reading every provision because of necessity. Notwithstanding anything contained in the foregoing provisions of this chapter, they mean Section 468. Notwithstanding anything contained in the foregoing provisions of this chapter, any court may take cognizance of an offence, after the expiry of the period of limitation, if it is satisfied on the facts and in the circumstances of the case that the delay has been properly explained. There are two limbs in Section 473. According to the first limb, the lawmaker has clearly coined the word on the facts and circumstances of the case if the delay has been properly explained. We know that to explain how the delay can be explained only by way of an application before the court. The delay can be satisfactorily explained before the court for the purpose of extension of the period of limitation, that is to condone the limitation, to condone the delay. The limb 2 is very, very interesting. The limb 2 is or that it is necessary so to do, explained, or that it is necessary so to do in the interest of justice. According to the Honorable Supreme Court of India and as decided by the Madurai bench of Madras High Court by His Lordship Justice P.N. Prakash in a case relating to accidental death, 304A of Indian Penal Code. By relying the judgment of the Honorable Supreme Court, the Madras High Court has held it is for the court to decide whether condonation of delay is necessary or not. According to the Honorable Supreme Court and the Pasupathi's case decided by the Madras High Court, even without an application by the investigating officer, as per the second limb of 473, Section 5 of Limitation Act says it can be condoned, but there must be an application, there must be a sufficient cause to be shown. In 473 also, no doubt if the investigating officer files an application showing the sufficient cause for not filing the final report on time, no doubt it can be condoned, but the duty is on the court as per the second limb of the 473. According to the 473 second limb, it is for the court to make cognizance. Section 190 CRPC speaks about to take cognizance, taking cognizance of offences. 473 CRPC second limb says the learned judge has to make cognizance. That is, on going through the entire materials available on record, if the learned judge feels the condonation of delay is necessary, the delay is necessarily to be condoned, then even without the application, it is for the judge to condone the delay without an application. Okay, sir. Then what is it time? From what date the period of limitation will begin, or commencement of the period of limitation? Only we know, only after knowing the commencement of the period, we can file 473 of application under 473. It has been clearly mentioned in section 469. No doubt only 7 provisions under chapter 36, but from the very registration of the FIR, even after the conviction recorded, there are restrictions in many ways given by the lawmakers. Let me read 469. Commencement of the period of limitation. The period of limitation in relation to an offence shall commence on the date of the offence, or where the commission of the offence was not known to the person aggrieved by the offence, that is the victim, or to any police officer, the first day on which such offence comes to the knowledge. When the first information has been given to the police officer, it will be the, then IO will be having knowledge of the offence. In computing the said period, the day from which such a period is to be computed shall be excluded. No doubt, in order to take cognizance, there is a limitation prescribed under chapter 36. It is not for all the offences. The heading itself is very clear. Limitation for taking cognizance for certain offences only, and that limitation is also not absolute. That can be extended. That extension can be given in 2 ways. Section 473, there are 2 limbs, and the chapter 36 speaks another thing, that is continuing offence. What is continuing offence? For example, the offence under section 498A of Indian Penal Code and 2 provisions under the Companies Act. There are 2 decisions. I prepared slide and I will upload it, and I will also ask my friends to give the citation at the back end. So, in so far as 498A is harassment, every day harassments are. So we cannot say the first day is the day to be computed. So it is a continuing offence. Offence is continuously committed by the in-laws. So section 468 bar is not applicable to the continuing offence. Then I will come to section 154 of CRPC. Then my learned friends may put a question. Sir, the last day for taking cognizance falls on Sunday. What is the remedy available? Can a complaint under 200 CRPC or final report under 173(2) CRPC can be filed, whether cognizance can be taken on next day? Is there any provisions? Yes, sir. Section 10 of the General Classes Act 1897 will come into play. Section 10 in the General Classes Act 1897 will come into play. The next day, if complaint or final report is filed, then it will be the last date. Cognizance can be taken. Then first information report. Anyone can set the criminal law in motion. Anyone can set the criminal law in motion, no doubt at all. Whether this has been restricted? Yes, this has been restricted. This has been restricted. No doubt. Cases, there are 2 types of criminal cases, everyone knows well. Cases instituted on a police report and cases instituted otherwise than on police report. Cases instituted otherwise than on police report. The restrictions given in various provisions, let me point out 196 subclass 1 CRPC, 196 1A CRPC, 196 2 CRPC, 198 and 199 of CRPC. Police cannot register FIR for the offence under section 138A of NAI. Police cannot register FIR for the offence under section 500 IPC. Police cannot register FIR for the offence under section 494 IPC. Police cannot register FIR for the offence under section 188 of 172 to 188 IPC. Let me take to section 195 of Code of Criminal Procedure 1973. We used to call the complaint filed under section 200 CRPC as a private complaint. As usual, I have one more doubt. We used to call the complaint under 200 CRPC as a private complaint. If there is a private complaint, then my brothers or any public may put a question, sir, is there any public complaint? Once we classify a complaint under 200 CRPC as a private complaint, then there must be public complaint. No doubt, there is a distinction to the complaint to magistrate. There are two types. One is complaint by private individual. For example, check bounce case under section 138 of NI Act. 138 of NI Act. And complaint by private individual. Complaint by private individual and complaint by public servants. Complaint by public servants. In section 195, 196A and 197, 198, 199, the clear language has been used. No court shall take cognizance. No court shall take cognizance. Let me read section 195 CRPC. Prosecution for contempt of lawful authority of public servants, etc. No court shall take cognizance. No court shall take cognizance of any offence punishable under sections 172 to 188, both inclusive of the Indian Penal Code, of any abetment of any criminal conspiracy, except on the complaint. Except on the complaint in writing of that court, or by such officer of the court as that court may authorize in writing in this behalf. So at this juncture, I want to say regarding the false complaint, false evidence, and forgery documents filed into the court. No doubt anyone can lodge the complaint. The locus standi to lodge complaint. Anyone, it is not necessary that an eyewitness alone can lodge a complaint. Anyone can lodge a complaint. Even on telephonic informations, FIR can be drawn. FIR can be drawn up and investigation can be taken up. No doubt. Now the question is, a tenancy deed was forged outside the court. A deed was forged outside the court. And the document has been presented to service before the court of law for the purpose of getting an order of injunction. For the purpose of getting an order of injunction. Now I am classifying into two. One is false document, forged document prepared outside the court. And another thing is false evidence. False evidence and false pleadings. Affidavit contains false falsity. And the pleadings are false in support of a forged document. Whether the plaintiff can file complaint before the police, whether the court has to file complaint. The fine distinction has been given by the Constitutional Bench of the Honorable Supreme Court of India. Constitutional Bench of the Honorable Supreme Court of India. The case was from the Madras High Court. The judgment rendered by the Honorable Madras High Court in Iqbal Singh case was confirmed, and fine distinction has been given by the Honorable Constitutional Bench of the Supreme Court of India. If a document is forged. If any forgery or any offense is committed over a document outside the court, and if the document is precedent to service before the court, then anyone can file a complaint before the police. No doubt the police can investigate. Suppose a document is very much available with the court, a document is in custody of the court, and some offense is committed over such document. That means offense has been committed over a document which is in custody of the court. Then no doubt the presiding officer of the court has to give a complaint under section 340 of CRPs. There must be an inquiry. And the complaint can be given only by the presiding officer of the court. There must be a specific finding, that is in the expedient interest of justice. The learned presiding officer has to give a finding. It is in the expedient, in the interest of justice. The making of complaint is just and necessary. So in such a way, the giving complaint and taking cognizance has been restricted over a forged document and false evidence. And insofar as offense under 188 of 172 to 188 of Indian Penal Code, very famous judgment of Madras High Court, namely Jeevanandam and others versus State. Many complaint has been quashed and direction has been given. Direction has been given by His Lordship Justician Anand Venkatesh. This has been reported in 2018, to Law Weekly Criminal, page 606. A guidelines was also given by the Honorable Madras High Court. The distinction between cases instituted on police report, cases instituted otherwise than on police report. That is, what is complaint defined under 2D of CRPC, what is report as defined under 2R of Code of Criminal Procedure has been well discussed, and a landmark judgment has been given by the Honorable Madurai Bench of Madras High Court in Jeevanandam and others versus Inspector of Police, Velayam Palayam Police Station, Karur District and others. A batch of quash application was disposed of by the Honorable Madurai Bench of Madras High Court. And by placing reliance on the judgment of Pasupati case, in Pasupati's case of accidental death, 304A, 3 counts. The final report was filed before the learned judicial magistrate with a delay. So an application under 482 was moved to quasi final report. The Madras High Court was pleased to help. As per section 473 second limb, the delay can be condoned by the court. No application by the investigating officer is necessary. The learned judge, the Honorable High Court, gave a finding that in the facts and circumstances of the case and the particular case, delay was condoned. Learned magistrate was directed to take cognizance and to proceed with the case. On relying upon the Pasupati's case, the Madras High Court reported in 2019 volume 3 LLJ, 2019 volume 3 LLJ, page number 21, between Sapphire Print Lab Knits and Woven Fabric Limited, Tirupur versus Deba and others. The Honorable Madras High Court directed the DGP Tamil Nadu to give directions to the police authorities to verify whether the final report have been filed on time. On the basis of these judgments, circular has been given by the DGP of State of Tamil Nadu. So, simply because the final report has been filed belatedly, the learned magistrate cannot refuse to take cognizance. It is the learned judicial magistrate to apply the second clip of section 473 and to take cognizance. Yes, sir. Now the final report, the FIR has been filed, registered. On going through the amendments made in the final FIR, some of the witnesses have been examined. Statements of witnesses under section 161 class 3 of CRPC was recorded. Then accused was arrested. Now the question is whether the police has got power, unlimited power, to detain the arrested person in their custody. Very, very grave offense. It requires many hours, many days to investigate whether the police has got unlimited power or the accused must be produced before the court. There is no specific limitation. The word limitation is used, but section 57 CRPC speaks the arrested person cannot be detained more than 24 hours. The arrested person necessarily has to be placed before the judicial magistrate concerned within 24 hours. No doubt. Now the accused is before the learned magistrate. Whether the learned magistrate can take the accused into custody for more than 30 days. Is there any limitation? Sir, the law says section 167 CRPC empowers the learned judicial magistrate and the special judges to take an accused into custody. No doubt, the power is vested with the learned judges, but that power is not unlimited. The power is power to authorize the custody is only 15 days. The initial remand is only for a term of 15 days as a whole, and that custody must be a judicial custody. No doubt, the first custody, the learned judicial magistrate has got every right. They have got power to grant the accused to police custody. No doubt, there are powers. But initially, when the accused is produced for the remand with a request to remand, that is to say, the detention of the police has been authorized by the learned judge. The first custody must be a judicial custody, and as a whole, the period must be 15 days. If there is no judicial magistrate, is available, then no doubt executive magistrate can also exercise the same power, and accused can be taken into judicial custody, but the period of custody is only for 7 days. Next, FIR registered, accused was arrested as per section 57. Within 24 hours, he was produced. Accused was taken into judicial custody. Then, immediately after taking an accused into custody, question of bail will come into play. Bail can be granted, no doubt. There is a restriction. The learned magistrate cannot keep the accused in custody. If no final report has been filed. If no final report has been forwarded. Section 167 2A2 CRPC restricts such power. If final report within 60 days or 90 days has not been forwarded, then accused is entitled for grant of bail. Indefeasible right accrued on the accused as per the constitutional judgment in Sanjay Dutt case and S. Kasi versus State, decided by Honorable Supreme Court from the Madurai bench of Madras High Court. And there are numerous judgments on the point, and after 60 or 90th day, the extension of remand is, then the remand will be illegal custody, bail can be granted. There is a restriction. No doubt, police has got power to investigate. That has been restrained. Anyone can take the criminal law in motion. There is a restriction. The learned magistrate has got power to take an accused into custody. the power is not absolute, there is a restriction, then we will come into play, whether the power under 167(2)(a)(2), that is default bail, is absolute, or is there any exception? No doubt there are some exceptions. Section 43D and 2B of UAP Act 1967, Section 36A(4) of NDPS Act 1985, and Section 2 of Gujarat Act in Gujarat, the Section 167(2)(a)(2) will not come into play, and the learned magistrate can permit the investigating officer to investigate some more time. Next, the after the remand, bail can be granted with condition or without condition. No doubt the learned judge has got power to grant bail with a condition. What has been restricted is the condition as embodied under the chapter bail alone can be imposed. Other than the condition mentioned in the Code of Criminal Procedure, other conditions cannot be imposed. Even in some cases, in some courts, the default bail has been granted with a condition to deposit cash, with a condition to deposit case. Whether such a power can be is available with the court or not, this has been decided by in many cases. In Madras High Court, I can cite 3 judgments and one from the Honorable Supreme Court, very recent judgment. Saravanan versus State. Saravanan versus State, 2021, Volume 1 SEC Criminal, page number 141. Saravanan versus State, 2021, Volume 1 SEC Criminal, page number 141. And Arun Kumar versus State. Arun Kumar versus State, this has been decided by the Honorable Madurai Bench of Madras High Court, criminal OP number 22400 of 2022. Criminal OP number 22400 of 2022. Reported in CDJ 2023. And Rajendran alias Tyagarajan versus State. Rajendran alias Tyagarajan versus State, 2019, Volume 2 Law Weekly Criminal, page 629. Rajendran alias Tyagarajan versus State, 2019, Volume 2 Law Weekly Criminal, page 629. Not only in default bail and in bail covered under the chapter bail, the onerous condition cannot be imposed. There is a restriction by the Honorable Supreme Court. There is a restriction by the in the Code of Criminal Procedure itself. There are decided cases. Yes, sir. Once bail is granted, is there any provision to cancel the bailer? No doubt. Bail once granted, that can be cancelled by the court which has granted bail. No doubt. There can be no second opinion. The court which has granted bail has got every right to cancel the bail. Sir, now the question is, A is an accused, granted bail in a bailable offence. Granted bail in a bailable offence. Whether this bail is absolute, whether this bail can be cancelled by the said principle, that is, the person who has granted bail is entitled, has got right to cancel. The court which has granted bail has got right to cancel bail. Whether the bail in a bailable offence can be cancelled by the learned judicial magistrate, Pillappan alias Ravi Kumar, decided by the Honorable Madurai Bench of Madras High Court, and very recently by Orissa High Court, The Honorable Madurai Bench of Madras High Court has held, if an accused is an application moved by the investigating officer to cancel the bail in a bailable offence before the learned magistrate, no doubt there is no provision, but what can be done is action, surety action can be taken. Surety action can be taken against the sureties, and there is a direction and guidelines given by the Madurai bench of Madras High Court. And the very recently Orissa High Court reported in 2023 live law. 2023 live law, the cancellation of order was quashed by the Honorable High Court Orissa. So, though there is no power, there is a power. The very same magistrate can cancel. The beauty is, very same magistrate has got right to cancel the bail in a non-bailable offence by exercising the power under section 437 subclause 5. 437 subclause 5 CRPC. He has got every right to cancel bail in bail non-bailable offence. Very great offence, very grave offence. But he cannot cancel the bail in a bailable offence. Why? For want of jurisdiction. The power can be exercised by the learned judicial magistrate only if the law gives power, if the law confers power. As like section 151 CPC, learned magistrate has no inherent power. If the court is district municip cum judicial magistrate, as a district municip, by exercising power under 151 CPC, some order can be passed. But the very same judge, as a judicial magistrate, has no inherent power. Sir, then what can be done in such a case? Section 439 subclass 2 CRPC will come into play. Section 439 subclass 2 CRPC will come into play. A high court or court of session may direct that any person who has been released on bail under this chapter be arrested and committed him to custody. So the bail in bailable offence, bail granted by the magistrate, bail granted by the sessions judge, anticipatory bail, and bail granted under section 167 subclass 2 CRPC, everything can be cancelled. There is a provision 439 subclass 2 CRPC, either by the court of session or by the Honorable High Court can cancel the bail. Sir, FIR registered, arrested, detained, detention was approved, bail was granted, then final report was filed, cognizance was taken under 190 CRPC, thereafter he was put on trial, charges has been framed, examination of witnesses are over. Now the learned judge convicted the accused. In one case, sentence of 3 years was imposed. In another case, by the session judge, 4 years sentence of imprisonment was awarded, and the sentence of life imprisonment, 3 cases for example. No doubt, as per section 389 of CRPC, the suspension of sentence can be granted. Suspension of sentence can be granted by the learned trial judge. Whether this power to grant suspension of sentence is absolute or is there any restriction? Up to 3 years of sentence of imprisonment. Learned judge can suspend the sentence, and more than 3 years, learned judge cannot suspend the sentence. And once the order of suspension of sentence is granted, if no appeal was filed and the accused, the convict, has not get the order of suspension of sentence from the appellate court, the learned trial judge has no right to extend it further. Once the suspension of sentence is granted, it cannot be extended. Chinmaya Sahu versus State of Orissa regarding the cancellation of bail by the learned magistrate, 2023 live law, Orissa, page number 78. Pillappan alias Ravi Kumar versus State, 2018, volume 2, MLJ criminal, page 502. Pillappan alias Ravi Kumar, 2018, volume 2, MLJ criminal, page 502. Page 502. Page 502. Then, if sentence of fine, if the fine has not been paid, there will be a default class. There will be a default class. The default class, default punishment is also restricted. Is also restricted by law. 1/4 of the maximum sentence alone can be awarded as default punishment. And one more chapter in the Code of Criminal Procedure, that is chapter 8. That is chapter 8, section 116 of 116 subclass 6. 116 subclass 6 of CRPC is very relevant to the topic. Let me read out section 116 subclass 6. This is the only one and only provision when after the cognizance is taken, after the trial is commenced. If the trial has not been completed within the period of limitation prescribed, it will terminated automatically without any further request. Let me read section 116 subclass 6. The inquiry under this section shall be completed within a period of 6 months from the date of its commencement. And if such inquiry is not so completed, the proceedings under this chapter shall, on the expiry of the said period, stand terminated unless for the special reasons to be recorded in writing, the magistrate otherwise directs. So, if a proceedings is initiated under chapter 8 of CRPC, the inquiry shall be completed within a period of 6 months. Otherwise, if no order is passed to continue the same for the special reason to be recorded in writing, the inquiry, the cognizance taken under chapter 8 shall terminate as soon as the 6 months time is completed. As soon as 6 months time is complete. Yes. Then yet another provision is section 167 subclass 5. 167 subclass 5. As per section 167 subclass 5, if investigation has not been completed in a summons case, 167 subclass 5 is a wonderful provision. Section 167 subclass 2 is a wonderful provision coined in tune with Article 21, like the same section 167 5 of CRPC. If in any case triable by a magistrate as a summons case, the investigation is not completed within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation. So the power of the investigation can be stopped. Further investigation can be stopped by the learned magistrate by invoking section 167 5 CRPC, provided the case must be a summons case. The investigation, if not completed after 6 months from the date of arrest, then the magistrate can direct to stop the further investigation. No doubt on the materials collected. During the 6 months, it is for the learned judicial magistrate to take cognizance. Then the punishment is there. No doubt the learned judge has got power to award punishment, conviction and sentence. If the learned judge comes to a conclusion that the prosecution has proved the guilt of the accused, the learned judge has come to a conclusion that the prosecution was able to prove the guilt of the accused, and he came to a conclusion to award punishment. Conviction has been recorded following the same sentence of imprisonment, sentence of fine and compensation will come into. Now there is a restriction. The learned magistrate can award maximum sentence or minimum sentence. But as per law, this power of awarding punishment has been restricted. There is a minimum punishment in several. There is a minimum punishment under section 302 of Indian Penal Code. What is the minimum punishment? Once the learned judge comes to a conclusion that this is an offense, this is a culpable homicide amounting to murder, then no doubt life imprisonment has to be awarded. Section 304B of Indian Penal Code, 304B Indian Penal Code. And in many cases, in curtain of cases, there are provisions. Let me read many provisions. It says compulsorily minimum punishment. Compulsorily minimum punishment. And in some cases, section 166A, 302, 304B, 326A, B, 354, 354B, 354C, 370 and 370A, 376A, 376B, C, 397 and 398 of Indian Penal Code. Minimum sentences has been provided. Only in very few cases, learned judge can award less than minimum sentence. Even for that, if at all there is a provision enabling the judge for the reason to be recorded in writing, unless power is conferred that for the reasons to be recorded in writing, the learned judge necessarily has to award the minimum sentence. No doubt judge has got power to award either of the sentence, maximum sentence or minimum sentence or any sentence less than. But in some cases, minimum sentence has been provided. This has to be scrupulously followed. Section 4, 6, 8, 10, 14 and other provisions of POSCO Act, Section 4, 5 and 3, 1 of SC/ST Act, Section 4 of Money Laundering Act, Section 8, 81 of Juvenile Justice Act, and many provisions under NDPS Act, and Section 26(2) and 26(5) of Payment and Settlement System Act 2007. And very recently, the Honorable Supreme Court has decided regarding the police custody. No doubt, so far we have followed. The police custody can be granted within first 15 days of custody. So there is a restriction by Section 167 of Code of Criminal Procedure 1973. The police custody, initially the first remand should be judicial custody. Thereafter, the police custody can be granted, no doubt. So far we have followed. It is only a first 15 days, and if accused is in custody more than 15 days, that is even on 16th day, 1 day later, police custody cannot be granted. This view has been modified. Now the latest view of the Honorable Supreme Court is, as a whole, the police custody can be granted. In V. Senthil Balaji versus State by Deputy Director, reported in 2023 for CTC page number 758. 2023 volume 4 CTC page number 758, V. Senthil Balaji case. V. Senthil Balaji versus Deputy Director and others. So, though chapter 36 from sections 467 to 473, only 7 provisions speaks about taking cognizance, limitation to take cognizance. It is also not absolute. It is also not absolute. Taking cognizance for certain offences alone has been, there is a bar, but without naming as limitation, right from section 154, right from registration of FIR, even after the awarding the punishment, there are a number of provisions speaking in a way limitation, limiting the power of the person concerned, power of the investigating officer, power of the learned judge. So in many ways, the lawmaker so carefully coined the restrictions throughout the Code of Criminal Procedure 1973. I will take 1 minute and I want to conclude. On every information, the language, please kindly go through section 154. On every information, FIR can be registered. even has to be registered if cognizable offence is made out. But on every information, a person cannot be arrested. You read the section 41, 154 and 41. The fine distinction is the arrest when the investigating officer collected more materials, then only arrest can be made. As per section 41 CRPC, against whom a reasonable complaint has been made or credible information has been received. On every information, FIR can be registered, no doubt. On the very same every information, that is on the very FIR itself, if there is no investigation and no statement was recorded from any witnesses, accused cannot be arrested. In order to arrest a person by invoking section 41, there is a restriction by section 41B CRPC. What section 41B speaks, against whom a reasonable complaint has been made or a credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence. So, on every information, accused cannot be arrested. The personal liberty cannot be curtailed. You just take section 167. FIR registered on every information. There is a restriction under section 41B. The investigating officer collected more materials. Credible information is there. On credible information, he was secured in order to forward an accused. Before the learned judge, requesting to remand. The section 167(1) speaks section so and so, and there are grounds for believing that the accusation or information is well founded. The only after the investigating officer coming to a conclusion that there are grounds for believing what, that the accusation or information is well founded. Grounds for believing that the accusation or information is well founded, the officer in charge of the police station or police officer making the investigation can transmit forthwith the accused to the judicial custody, before the judicial magistrate, and the judicial magistrate, on going through the entire materials, even including the first diary, before taking an accused to judicial custody, simply because there is an FIR, the learned magistrate cannot take an accused into custody. He must go through the first diary, he has to go through the entire materials, and he has to come to a conclusion that there are grounds, there is a prima facie case, and then only the learned magistrate can take the accused into judicial custody. Then only the learned judicial magistrate can authorize the detention of the police officer. With this, I want to conclude. My sincere thanks to the organizers of this webinar, and Mr. Vikas, my sincere thanks, and also to my learned brothers and sisters who have paid their time on Sunday. Dhanyavad.
Thank you, Ji, for sharing your knowledge. Meanwhile, we have two questions. Sachin Sharma says, what is the process to take sanction for cognizance in specific section like 153A IPC for advocates?
Section 153A, in order to take cognizance, that is, when a learned magistrate is going to take cognizance on the final report, if at all there is a sanction to prosecute, no cognizance can be taken, no doubt at all. If cognizance is taken without a valid sanction, then it can be quashed. But provided, in order to take him into custody for remand for very limited purpose, as decided by the Honorable Supreme Court of India, the remand can be ordered. From Bangalore case, the Honorable Supreme Court so categorically said, cognizance at the time of taking a person into judicial custody, it is only a limited purpose. The bar will not come into play. The bar created under law, under section 195 CRPC will come into play. Only a final report is considered to proceed with the trial. That is a distinction.
In case of adultery, is there any limitation to file a petition for divorce and maintenance?
Sir, pardon, sir.
In case of adultery, is there any limitation to file petition for divorce and maintenance?
Divorce and maintenance, there is no provision for divorce. For criminal prosecution, there is a
Okay.
period of limitation, and it can be also be extended.
Rest of the messages are thank you for wonderful session. This is by Sanjeevani. Parthiv Kannan says super. Then Ajit says super session. Naveen says that was for recognizing my concern. And thank you for sharing your knowledge, Mr. Karunanithi. We are obliged the way you subtly explain all these things. And that's why we can understand that why you were nominated to be a part of the member of the Law Commission. Thank you, everyone. Thank you.
G, one request. I have circulated some slides to you. If possible, you circulate it in your
I will
website.
do it on my website.
Yes, sir.
Thank you. Thank you.
Yes. Thank you very much for having given me this nice opportunity to meet the youngsters of this Bharat. Jai Hind.
Jai Hind.